Well, and you saw here on News from Africa last night, confirmation lawyers for former President Jacob Zuma sending a letter to the Zondo Commission chair asking for the Deputy Chief Justice, Raymond Zondo, to recuse himself as chair of the commission. They say he's biased against Zuma and that he has a personal and professional history with Zuma that he should have disclosed before taking on the chairmanship of the commission. Pierre de Vos is a professor of constitutional law at the University of Cape Town. Professor, good afternoon to you. From what we've seen so far, does Zuma have any case against Judge Zondo?
Well, we'll have to see if anything else comes out or is revealed, but as it stands, I don't think that the recusal application is going to be successful. The first problem is that recusal is usually done by somebody who is presiding in a court or in another adjudicative body. So it's not so clear to what extent it will apply to a commission of inquiry and a chairperson. Of course, the chairperson mustn't be so biased that it influences the outcome of the report, because then the report can be set aside. But yeah, it's not clear. But if you assume that it's possible, the problem is that you have to show, and the onus is on President Zuma, that a reasonable person, not the person that is Mr. Zuma, has a real apprehension of bias. The assumption set the Constitutional Court is that that is not the case. So you'll have to come with real evidence that there is a reasonable fear that the person will be biased. What we have seen so far, that is not going to happen. Even if it was a court of law, the judge would not have recused himself.
I would imagine that the perception of bias can actually be quite hard to argue in court. I don't even know if there's a legal test for it.
Well, the court has said, well, firstly, it's the person who's being asked to recuse him or herself who has to decide the matter. And then you have to ask, well, is there something there that a reasonable person, somebody with all the facts, somebody who's not overly suspicious or is worried that the decision will go against them, that person really has a fear that you're going to be so biased that you're going to make a decision that you otherwise would not have made. So that's what the test is at the moment. It's very seldom successful. There was a case where Louis Lake, I don't know if you remember him, asked judges of the Constitutional Court to recuse themselves because they were pro-ANC, that one of them, his son, President Mandela, attended his son's wedding. The court said there was not snowballs opening hell that we're going to recuse ourselves. We have a duty to sit here unless there's actually a real apprehension.
I'm not at all surprised to find that Louis Lake tried to make that kind of application. If there was a personal history between these two men, and I'm talking about Judge Zondo and the former president, would it matter? And I mean, what I'm saying is, if I was the lawyer representing Judge Zondo in such an application, I would say, well, it didn't seem to matter when the now former president nominated Judge Zondo to be the Deputy Chief Justice in the first place in 2017. And of course, there's a statement, I think a lot of people have been looking at it this morning, that when President Zuma, as he then was, had to formally appoint Judge Zondo to be chair of the commission in 2018, it was in January, the last days of his presidency, he told people to cooperate with the commission, didn't he? I mean, it would seem difficult to bring up any history now.
Well, I'm not sure legally that is a good argument, because if there is really something that shows that Deputy Judge President Zondo cannot be impartial, then there would be a problem, because then there would be potentially maybe a legal problem, but there will be a political problem in that the legitimacy of the commission will be tainted. But that would have to be more than just we are cousins, or my wife divorced your brother, or whatever the case might be. It will have to be something really tangible to have that effect. We don't know, of course, if there's such a thing.
Okay. Could there also be a way in which an applicant, whoever they may be, but the former president in this case, could try and have several bites of the cherry? Now, I'm not going to mention the name of a Russian city, but you'll know that the name of that Russian city is replete in the law reports, right? So what you would have is, could Jacob Zuma, the former president, so first lodge an application now. Judge Zondo, please recuse yourself. The judge refuses. Then he appeals, etc., etc., etc. We've been through all of that before. Then the findings are made. Could he then go to court against the findings? In other words, could he try and lock this down in litigation, well, forever?
Yes, so the thing is that he could challenge the refusal to recuse, but that's going to be difficult because no decision has been made, nobody's rights have been implicated, so it will be I'm not sure how that will work. It will be, I think the recusal is more to give President Zuma a plausible excuse not to heed the summons, because the law says you have to heed the summons, you have to come and testify if you summon, unless you have sufficient cause not to. So they can argue, well, having the recusal application is sufficient cause. So I think this application is really not about the commission, firstly. It's about the testifying and having an excuse not to be found guilty of a criminal offense. Once the report comes out, then it can be reviewed and set aside. One of the grounds for review could be that the chairperson was so biased that he made decisions that was not rationally justifiable to be made.
There's a sense of inevitability around all of this, isn't there? That as the Zondo Commission was getting to the sort of business end, that someone would threaten court action. And I suppose it's probably no surprise, if I may say, that it is former President Zuma who is doing this. What happens if he just doesn't come and testify?
Well, if he doesn't come and testify, then there's a gamble, because on the one hand, then all the testimony of the people who testified against him goes unchallenged. Now, this is not a court, so the commission itself can find evidence, they can find exculpatory evidence and so on, but it does make that's why, from a purely legal perspective, it doesn't make sense for him not to testify, because without his version, it's more likely that they will find against him. But the real issue is the legitimacy of the report. I think 3/4 of all these legal maneuvers are not really about the law. It's about whether the report is going to be credible, because the report is not binding. It cannot make any binding decisions. It is only advice. And so it depends on whether the report is credible enough so that there will be political will to act on it.
You old cynic, you. Professor Pierre de Vos, thank you very much indeed. Professor of Constitutional Law at the University of Cape Town.